Daphna, you've written about what you call the president's two bodies, drawing on a term that's often applied to the medieval king or kingship. This is the idea of the charismatic individual leader, a person, versus the office of the president or the presidency. And you've also written extensively about the norms that, at least before this president, have applied to the president and the presidency. So where do we go from here?
Great, thanks so much, David, and thanks so much to you and to the ALI and to the Bold Judicial Institute for having us all together for this conversation. So I thought I'd follow up initially on David's historical context and offer some conceptual context for the constitutional office of the presidency, and then get at your question about this particular president in our current moment. And my argument is that American constitutionalism consists of two quite foundational, quite conflictual, but ultimately interdependent understandings of the presidency. And that's what I've suggested we could think about as the president's two bodies. So on one view, the presidency, the office, is an individual. It's a he, maybe one day a she. And this understanding of presidential power is individualistic along three dimensions. It's personal, so the individual arrives in office with a particular set of ideological and political and moral commitments, and his constitutional obligation is to execute this particular vision of policy and governance. It's temporary or presentist, so the characteristics of the office are ephemeral. The commitments that one president makes shouldn't disable the governance and policy discretion of his successors. And it's singular or unitary. On the other view, the presidency is an institution, and this view is more impersonal, it's more permanent or at least indefinite, and it's composite. So as an institution, the constitutional office of the presidency is comprised of certain features. These are deliberative practices or norms, substantive commitments, institutional restraints that aren't fully within the control of any one occupant. And this also means that the characteristics of the office are more stable and continuous. So internal practices and executive branch precedents that form under one incumbent continue to govern successors. And statutes enacted under one president are then defended in court by his successors. And it's composite or collective. So these other actors protect and even augment presidential power, even as they also entrench limits on the will of the sitting president. And ever since George Washington embodied the idea of an institution that was still in the making, we've had this deep tension, these competing impulses between a personal or charismatic president on the one hand and a more impersonal and deliberative presidency on the other. And as you say, these two understandings of the presidency, they have a prehistory in the doctrine of the king's two bodies, in recognizing the person of the king as distinct from the institution of kingship. The king's duality provided what we all know today was a crucial building block in the creation of the modern state. But there's also this unfinishedness, this kind of enduring inseparability to the two bodies that I think we see reenacted in different terms in the context of the US presidency. The two bodies plays a role in how we understand the legitimacy of presidential power by equivocating on the idea of the president. So the president means two different things. It has these two different bundles of attributes. And that makes it possible for constitutional and political argument to obscure ways in which each body creates some real unease by emphasizing attributes that inhere in the other body and by suggesting or implying that those attributes pertain to the constitutional president as a whole. Even as it obscures presidential power in this way, the two bodies is also constitutive of a presidential office that actually embodies aspects of each. So it orients practice toward these two intractable but ever-present impulses for what the constitutional office should actually entail. And we see across constitutional history and across constitutional law different variants on the same basic tension or struggle. So a key debate at the Constitutional Convention is, how do we construct an office that creates some space for individual responsibility and personal judgment while resisting self-dealing or the corruption of public power? And this tension recurs in a different form for progressive thinker reformers in the debates about how do we structure the executive office of the president. On the one hand, to facilitate policy leadership through the person without making the office too contingent on any one man's whim or fancies. And we see it throughout our public law doctrine. So even within the same case, the court's separate opinions are often proceeding from what are incommensurable and often unarticulated starting points relating to the individual president and the institutional presidency. Now, my argument is that there's no final answer between these two bodies. Public law theory can't somehow solve or move beyond the president's duality, but it can make it central. And in doing that, we can better understand the nature of the problems and the structure of our disagreements and the constituted reality of the office. So if that's my conception of the presidential office, what does it mean for this particular president and our current moment? I'll offer a few thoughts. So at one level, I think Trump has tried to disrupt a longstanding precept when it comes to the duality, that some conceptual and constitutional space for the person's moral and policy leadership not collapse into the use of power for purely private gain. Ever since the framers debated term limits and presidential impeachment, the disagreement has been over how we institutionalize a space for personal judgment, for charismatic leadership, while resisting self-dealing or the use of public office for private ends. And Trump's insistence over and over again in his actions and his rhetoric that this is a distinction without a difference flies in the face of constitutional and political development over the centuries. At the same time, the Trump presidency brings into view some problematic developments of the duality if this continues to be a constitutional goal. So public law has become ever more protective of the personal charge of the president in controlling administration, even as there's this deep reluctance to adjudicate the personal responsibility of the president, and it takes different doctrinal forms. And the result is a potentially potent mix of personal control and personal impunity when it comes to presidential power. And I think that's a legal possibility that we've seen in some ways realized in the actions of the sitting president, and in some ways, a court starting to cabin this problem in its recent decisions. Relatedly, I think at the crux of the Trump presidency is what we might think of as a problem of acoustic separation with respect to the two bodies, or the separation between the anti-constitutional commitments that the incumbent as a human being conveys, so policy in furtherance of religious animus or retaliation for political dissent, and the official conduct that courts or Congress are expected to check. There's a danger for a working system of legal and political accountability in a president who can avow one thing as the person and then purport to do something different entirely as the institution. And I think one thing we've seen in the last couple of years is a court really coming to appreciate this danger, both for the legitimacy of the office of the president and also for the legitimacy of the court itself in ways that we might get into further in our discussion. And finally, I think the Trump presidency illuminates a more structural change if we think about it in relation to the king's two bodies. So with the king, there was the real person and the fictive immortal body. And this second body becomes a way for lawyers and for jurists to justify constitutionalism as a custodian of a perpetual public good. So an impersonal, even continuous public interest, in turn, is what creates a space for legal incursions on the mystical crown. It allows constitutionalism to check the personal power of the monarch. With the American presidency, the impersonal, the immortal body, it's become institutionalized. It's real. It's populated by thousands of individuals. But the fictive or mythical idea of sovereignty has become deeply personalized. Public law theory and doctrine justifies a profound reimagining of our national commitments every 4 years through the charismatic legitimacy of the president. And in that sense, the Trump presidency is really of a piece with a much more long-term development in the presidential office, even as it illuminates for us what happens when you take this vision to its quite horrifying extremes.